Good evening, everybody, and thank you for coming to this annual occasion, which is always a great event in the LMH calendar. I can see a lot of faces who know Don and Suzelle very well and don't need any kind of introduction, but to those of you who are younger, if I can put it like that, and welcome to them to this is an occasion that's been going for many years. Suzelle has an almost lifetime connection with LMH. She came here in 1975 to study for an MPhil in politics. And it's sort of been a family affair ever since, hasn't it? So she's been here back repeatedly and a good friend to the college over the years. Don wasn't here, but he married into the college, so that was good. And then there were two daughters and two children and a daughter-in-law who came and studied here. So LMH has served as a kind of dating and marriage agency as well as a place of education. And if that wasn't enough, Don and Suzelle have both been tremendously generous benefactors to the college. And as if that wasn't enough, they also take law students for an attachment that is so mouth-watering, involves 9 months fully paid work in Malibu and at a beachside cottage. Now, when I first heard about it, I asked if I could apply for it because it seemed to be wasted on the students, but they wouldn't have it. They're members of the Vice-Chancellor's Circle, which is a very select group of people who are especially friends of the university, and they're good friends to David MacDonald's Wild Crew as well. When you come down the Norham Gardens now, the new vista that faces you has got those wonderful gates, which are the Don and Suzelle gates. I don't think they're officially called the Don and Suzelle gates, but that's what we call them. And in addition to all that, they're distinguished lawyers with their own firm in Los Angeles that does a tremendous variety of stuff, from fraud to copyright, from tackling the Vatican to major film studios, from terror cases to antitrust litigation, from personal injury to white-collar crime. And my sense of them is, if, God forbid, any of us were any trouble at any points in our lives, these would be very good people to turn to and have them on their side. And my sense is also, if you got into trouble, you would badly not want them on the other side, because I think they are fearsome, tenacious litigators who never give up. And I think that's what we're about to hear about. And in addition to being wonderful litigators and all of the things I've just said about them, they are very good advocates on their feet and extremely good raconteurs. So I know we're going to have a terrific hour or so before we hit the drink. So Don and Suzelle, thank you.
Thank you, Alan, for that lovely introduction. And we do have many of you in this audience who are friends or clients or family, and it always feels like coming home when we come to Lady Margaret Hall for all the reasons that Alan said. So we're very glad to be here tonight. This is a little bit of a difference from our usual format. For those of you who are loyal followers like Felicity Bryant, who I think has been here for every one of our lectures for almost 20 years, we usually have a guest speaker. And this time we thought we would just have Don and Suzelle. So Don and Suzelle we will do the presentation without anyone joining us at the podium. But we're going to talk about a case that is got just about everything to hold your interest. It's got sex, it's got drugs, and it's got money. So if this one doesn't ring your chimes, I don't know what will. People often ask me, I've been practicing law for over 30 years now, and we have had, as Alan recited, an incredible roster of cases over our time as trial lawyers with amazing clients and amazing stories. But when people say, well, what was your favorite case? I really have to say the Doris Duke case for a number of reasons. because of the sex, death, murder, drugs. And in an unusual way for a solicitor or a barrister in your country, Don and I are percipient witnesses to the drama that we're going to tell you about that's going to unfold. And the reason we're percipient witnesses is there was a time when Doris Duke was alive when we were her lawyers, and then after her death we were involved in the fight over her estate, and I'll tell you a bit about that as we get into it. The way we're going to set up tonight is that I am going to give you some of the background about Doris Duke, and first I'm going to tell you we did a dress rehearsal on this presentation at Trinity College in Dublin about a week ago, and when I stood up to make the introductory remarks, I looked out at the audience and they were very young. And some of you are young and some of you are not so young. But I said, all right, everyone raise their hand who actually knows who Doris Duke is. And there were only a few hands that went up. She was born in 1912. So I'm going to give you a little bit of background on who Doris Duke is. I'm going to give you the background on how Don and I came to know her and be involved in the case. And then Don is going to tell you more of the sort of nuts and bolts about the lawsuit, what role we played, how the case was cracked, if you will, and the end of the case. And then after we finish, we're going to leave time for questions, because in Ireland we had quite a few questions, as you might imagine, with the theme that I've just told you about. A lot of people wanted to know the backstory on a number of aspects of the case. So we're open. We'll tell you anything that you want to know. Doris Duke. So Doris Duke was the daughter of James B. Duke. James B. Duke was a robber baron. He monopolized, or his companies monopolized, tobacco and electric power in the southern part of the United States. And he amassed, for the time, a huge fortune. It was about $200 million when he died in 1912. And in 1912, that was a goodly sum of money. He left his fortune to his daughter, Doris. She was 12 years old. And she became the richest little girl in the world. I think even richer than the Queen, Doris Duke was. So the thing about that in United States tax law, which might be of interest, is that if you were a minor in 1912 and you inherited that kind of money, you paid no estate taxes, and you also paid no income taxes on the interest to that money until you actually reached 21. So that estate accumulated, the estate that she inherited, and at the time of her death, it was an estate with about $1.2 billion in liquid assets and a lot of real property and art and old masters, and I'll tell you a little bit about that too. But I think this will give you some idea of the life of Doris Duke, this very, very wealthy 12-year-old. On his deathbed, and Miss Duke told me this herself, her father called her to his deathbed, and virtually his dying words to her were, Doris, no one will ever love you for yourself. They will only love you for your money. And so that sort of informed her life. She took that to heart, and that was the way she lived her life. She never trusted anyone. That was perhaps a self-protective instinct, but it also became a very self-destructive instinct, as you'll see as we go through the tale. So she was the wealthiest little girl in the world, and she grew up very much a debutante of the time. The Woolworth heiress, Barbara Hutton, is often confused for Doris Duke. Two different people. Barbara Hutton was Woolworth. Doris Duke was the tobacco and Duke University. Her father endowed Duke University. So those of you who know Duke, that's the family. She had a couple of marriages. She had no children. She divorced two husbands. One was a man named Cromwell, who she married, and they had an estate in Hawaii. The other husband's name has escaped me, but the marriages didn't, sorry? Rubaroso, oh yes, how could I forget him? The playboy Rubaroso, who was supposed to be incredibly well endowed, not with money, but with other features. But the marriages didn't last very long, and she had one child that was born and died 11 days after the birth. So she had no immediate family during her life. She did the typical things that an heiress and socialite and debutante would do. Because she was so wealthy and incredibly wealthy at her time, she could pretty much command an audience or a dinner or a lunch with anyone that she wanted because of her great wealth. And she had somewhat of a chip on her shoulder because she was an intelligent woman. She was not educated beyond high school, and she always felt as if she wasn't really making a contribution in life. And there's some truth to that. She really didn't use her money or her talents or her gifts well during her life, and money isn't everything. It can buy you an entree, but it certainly can't buy you happiness. I'm going to fast forward. Doris Duke is now about 75 years old, and she meets a young woman named Charlene Heffner. And she adopts this young woman who's 35 years old, and there was a very close relationship. Some think it was more than a mother-daughter relationship, but Charlene then became the presumptive heir of the Duke fortune and Miss Duke's close confidant. So Dawn and I come into the story because in 1988, Charlene Duke Heffner was adopted, and the picture that I could find of Charlene and Doris Duke together is the one with 3 people in it. The other one, the woman on, let's see, the right, as you're looking at the picture, is Charlene Heffner. The woman to the far left is Doris Duke, and the woman in the middle, for those of you who don't recognize, is Imelda Marcos. And it just happened to be the picture that I could find. There is a little side note on this. Imelda Marcos, when she got into trouble in the United States and she was being tried for embezzlement and extortion and high crimes in New York, she wanted to hire a very well-known lawyer named Jerry Spence, who was from Wyoming. He's the one with the cowboy boots and the cowboy hat. He was quite notorious in his day, but a very good trial lawyer. But Spence realized that the Marcos fortune was pretty much locked up, frozen by the government. So he said, I'll represent you, but I want $5 million in cash, win or lose. So Imelda Marcos went to her friend Doris Duke, borrowed $5 million and gave Jerry Spence his fee. He did, in fact, get, I don't know if you all remember, but she was acquitted, and the evidence was pretty strong against her, but Jerry Spence acquitted her. She didn't pay the money back to Miss Duke, and so one of the things when we were hired on to do was to get the money back from Imelda Marcos, which we did manage to do. So we got the $5 million back. The other picture I'm showing you, so the woman in the sort of sarong white dress with the blonde hair is actually Charlene Heffner. And as I go along and we start learning more about the persona dramatae of the story, the people who were around Doris Duke often started to look like her. And so you can see Charlene in the beginning with the dark hair and her own haircut, and now you see her and she's got the blonde, long hair. People started to sort of assume the visage of Doris Duke. I don't know why, but as we go through, you'll see. So Charlene was adopted by Doris Duke, and that went well for a while. They bought a 737 plane. It was the largest private plane owned at the time, and flew all around the world. And Charlene was a dutiful daughter, and Miss Duke was a doting mother. She bought her a big estate in Hawaii where Charlene had her horses. But then Charlene made an unpardonable mistake to Doris Duke. Miss Duke wanted people to pay attention to her. You needed to be the center of the universe, and if you paid attention to anyone else, it was danger time. So Charlene took up a relationship with one of the security guards at the estate in Hawaii, And as Miss Duke told Dawn and me when we first met with her, she moved him into the house and then she moved him into her bed. And this was a mistake because Doris Duke was a very possessive and jealous woman. So not long after these events occurred, Doris Duke decided that she wanted to disadopt Shondi Heffner. So this is how we come into the story, because there was an expert witness, a doctor named Harry Demopoulos, an oncologist, a researcher in New York, a cancer researcher in New York. And he had met Doris Duke because he did a cancer protocol with high doses of antioxidants, which in today's world doesn't sound very strange to us, but at the time Harry was doing the protocols, it was really very, very avant-garde and breakthrough. And he had a lot of celebrities who wanted to be in the protocol, I think because they thought they were going to live forever, or, you know, it was the fountain of youth or something. But so Sylvester Stallone and Clint Eastwood and other people of the time were in the protocol, and Doris Duke. So she became close friends. Dr. Demopoulos watched this protocol, followed the group, the cohort, for a number of years, 25, 30 years, and he became friendly with many of the people that were his guinea pig test subjects. David McDonald does that too, I'm told. He becomes friendly with his, with his test subjects. But in any event, Dawn and I were in Los Angeles, and Harry Demopoulos, who had been an expert witness for us and was a close friend of Doris Duke, called us and said, "Do you know who Doris Duke is?" And we said, "Oh, she's the Woolworth heiress," just like everybody does. And he said, no, that's Woolworth. And we said, "But isn't she dead?" And he said, "No, she's not dead. She's still alive." And we said, "Okay, yes, we remember Duke University." So Harry said, "Miss Duke has a problem, a legal problem, and she needs a lawyer. And I've told her that you are great lawyers, and you're the one she needs to see." And we said, "Well, what is it about, Harry?" And he said, "Well, she wants to disadopt this young woman that she adopted." And we said, "Well, we don't do family law. That's not the right, it's not the right case for us, but we'll get somebody quite good." And he said, "Well, no, I've actually promised her that I can deliver the two of you. So will you go to Falcon's Lair, which is one of her homes in Los Angeles? It's the old Rudolph Valentino estate. So will you at least go and have tea with her and just meet and talk with her and listen to the problem?" And we said, "Well, sure, you know, we'll dine out a couple of times on the stories of meeting Doris Duke, I'm sure." So we went over, and we were shown into the mansion by Bernard Lafferty, and the title of our talk is "The Butler Did It." Well, the butler was a man named Bernard Lafferty. Bernard Lafferty was Irish by descent, by birth. He was born in Ireland, and he was someone that Shondi Heffner brought into the household when she came in and was adopted. He had not been with Miss Duke since she was a child. He had been with her about 5 or 6 years when we first met him. And she was very much of the, I'll call it old school mentality, that the servants are the servants, and you know, they're not this, they don't sit down at dinner, they don't sit down and have tea, they bring the tea and they do the serving. So when Bernard showed us in, Miss Duke wasn't, she was going to make an entrance, and he showed us in, and I'm from the South, my mother's here, we're from the South, we're very friendly, we hug everybody, like Meghan, your new princess, or Duchess, you know, we hug people, that's what we do. So I was talking to Bernard the butler, and I said, "Oh, have you been with Miss Duke, you know, for a long time," and chatting him up, and Miss Duke came into the room, and she observed me talking to Bernard, and then she sent Bernard off to get the tea, and she turned to me and she said, "Suzelle, if you want anything from my servants, you ask me. Don't talk to the servants." So she didn't say it meanly, but that was the way things were to be done. I tell you that, as I said, Dawn and I are precipient witnesses to what unfolded. It's important because Doris Duke did not consider Bernard Lafferty a member of the family. She did not consider him a trusted confidant. He was very much the man that the bell was rung and he came in, and he left the room before we ever talked about business. So we sat down, Miss Duke told us what the problem was, and she said that, oh, by the way, when Shondi Heffner was adopted, Ms. Duke changed her will, and Charlene Heffner became the trustee and executor of her estate. Now, Doris Duke wasn't leaving to individual people her vast fortune. It was going to charity, and it had always been set up that way, that it would go to charity. But the trick was, who was going to be in charge of the charity? Who was going to be the executor and trustee of that charity? Doris Duke also had a favorite game she played, which was to bring people in and out of the will if you were up or down in her good graces. And so she used that to pull strings, be the puppeteer with people her whole life. When we came to see her, she had a will that was written by White & Case, a very reputable law firm in the United States, and Charlene Heffner was the executor and trustee. And in that will, like all the wills, up until the one that I'll tell you about, the lawsuit was over, there was an individual executor and trustee and an institutional executor. They were co-equal. They had to make decisions together, and you can see the reasoning for that. If it's a charitable estate, you want to have someone who's not an individual alone having access to the vast fortune. So Charlene was in that position. So Dawn and I come in, we're having tea. Ms. Duke says, I want to disadopt. And we said, Ms. Duke, we're not family law lawyers, but we can tell you this. If you do a proper adoption and you go through the legal hoops, in the eyes of the law, it is exactly as if you had had a child by birth, a child of your body. In the eyes of the law, she's your daughter and you can't disadopt. And she said, nonsense. I've divorced 2 husbands. I can disadopt. And we said, no, actually you can't. But what you can do is you can disinherit, just as you can disinherit your own children, and mine are sitting in the audience. You can disadopt you can disinherit your adopted daughter. And so what you need is estate lawyers who can do that, and they can put in a new executor and trustee. So after she sort of choked that down, she said, all right. So she said, here's what I want to do. I want to hire the 2 of you, and I want you to, I know you've told me that you don't do estate work, but I want you to be sort of my general counsel. And I want you to be the lawyers that I come to when I have a problem, and then you can hire other lawyers for whatever specialty you need, but you'll be the liaison. I'll deal with you, you deal with the rest of the team. And I said, true story, I said, well, Ms. Duke, that really isn't going to work. And she said, why not? And I said, because, number one, we're too expensive. She has a reputation for being very tight with her money. We're too expensive, and number 2, if we did do it, not only would we charge our normal hourly rate, but we would charge you the, forgive my French, pain in the arse surplus. Now I can say arse because our President of the United States has got a potty mouth, and so all Americans now are interjecting, colorful metaphors into our talks. So she said, well, what do you mean? And I said, you say to people, jump, and they say, how high? And you want to call people on the weekend and at 2 o'clock in the morning, and that's not what Dawn and I do. That's just, we're just not interested in that kind of a relationship, but we'll get you good lawyers. Well, you can see where the end of the story is going. The more we protested, the more she had to have us. So she sort of made us an offer we couldn't refuse, and we became her general counsel, and we worked with her for about 2 years and did all kinds of interesting things. I actually haggled over a Persian rug for Ms. Duke at one point, but she had all kinds of things she wanted done, but we would hire the lawyers, and in the case of the will, we hired McCarter and English, which is a firm in New Jersey. And McCarter and English drafted a new will, taking Charlene Heffner out of the will and putting in Dr. Demopoulos, remember the expert who put us in touch with her in the first place. And she told us that she wanted Dr. Dimopoulos to be the new executor and trustee because she wanted someone who would make sure that the money was going to medical research, environmental, animal protection, colleges, like ones we were fond of. And she thought Dr. Dimopoulos would be a perfect choice. Under the Dimopoulos will, which I will call it, there was also an institutional trustee. It was Chemical Bank. And so McCarter and English wrote that will. Doris Duke executed. We had all the witnesses. We all flew over to Hawaii. We did it. Everything was done properly. And life went on. Now Shondi's out of the picture. And so Bernard Lafferty, the butler, starts to make his move. He knows that he doesn't know what the terms of the Dimopoulos will terms are, because he didn't have anything to do with it. But he suspected that he wasn't in the will. So he devised a scheme to take advantage and take control of Doris Duke, and the ultimate goal was to murder her and for Bernard Lafferty to become the executor and trustee of the estate. So Bernard sort of quietly and slowly infiltrated himself into Doris Duke's life closer and closer. He cut out other people. One of the things people ask me, because we'll get to the death scenario, and people asked Dawn and me, well, you were lawyers, why weren't you doing something during the last sort of 9 months of her life? And the answer to that is that Bernard Lafferty did start cutting people off. Doris Duke had called me about 10 months before she died. I returned the call. Bernard answered the phone, and I said, Ms. Duke has called me. I'm returning her call. He said, oh, she's indisposed right now. She'll get back to you, and she never did. Now, it's not unusual. Most of you in this room are lawyers or professionals and sophisticated people. Dawn and I don't call up our clients once a month and say, hello, have you got something for us to do? We're your lawyers. We wait for you to call us, and if you have something for us to do, that's fine. If you don't, you don't. So it wasn't anything that we were sitting waiting for Ms. Duke to ring the phone. But she did try to reach me. I did try to reach her. And at that point, Bernard was cutting off people, including Dr. Dimopoulos, who was in a similar situation. He had called. He had sent her some roses and chocolate. She loved presents. And he didn't get any response back. But you know, he just thought, well, she's a mercurial person. She has favorites. She loses favorites. You go in favor, out of favor. Maybe she just doesn't want to see me anymore. So nobody on our side knew what was behind the curtain that is going to be drawn for you now. So, Cat and Muchin. First, Bernard got in some new lawyers, reputable law firm, Cat and Muchin, out of Chicago. They put a team on it, as you can imagine. They charged her a fortune. And they got the bad lawyers in. This is around, Bernard starts making his move around the end of 1992. Gets the new lawyers in. They want to get Doris Duke to sign a new will. But they know that they can't get her to just read a will and see that Bernard Lafferty is going to be the trustee and executor. There are also some bad doctors in this story. The lawyers and Bernard convinced Ms. Duke to have a facelift in the year early 1993, and some other cosmetic surgery that she didn't need, and it didn't go well. She wasn't in great shape, and it was ill-advised for her to get this cosmetic surgery. She did it. She was in Cedars-Sinai. But she came out of it, and she probably would have been all right, but they moved her back to her estate, Falcon's Lair, and then the doctors and Bernard started taking control of her medical care, and they started giving her cocktails of drugs to keep her essentially sedated and comatose. They did bring her out long enough to sign a will, and Dawn will tell you more about that. And that was the last will in time of Doris Duke, was the one that left Bernard Lafferty in control. So the Lafferty will, Lafferty was smart enough, he didn't just make himself the heir, he made himself the executor and the trustee of the charitable trust, the charitable estate. So this meant when she died, he was going to come into control of over $1 billion in liquid assets. And he also, there was a co-trustee relationship, but this they did, and it wasn't very clever, but it would have given them, ultimately, if they had succeeded, it would have given them enormous power. Remember I said in all the prior wills, the individual executor and the institutional executor had co-equal power. They changed that, and they gave Lafferty the ability to fire, to terminate the institutional trustee, which in essence gave Bernard Lafferty control of the charitable trust. If you have a choice between inheriting a $2 billion estate or being the executor and charitable trustee, you might want to consider being the charitable trustee, because you'll never buy dinner again. The institutions of the world will take you out and wine and dine you. Also, if relatives, poor relatives and friends come and ask you for money, you have a perfect excuse. I'm just the trustee. I can't give my friends and family money. But in New York, it was a 6% of the state fee for being the executor and the trustee. So it was an amazingly lucrative position to acquire. So Bernard had the discretion to fire, and his is the presumptive last will. And when Doris Duke dies, that is the will that is subject to probate, and that will was challenged. That will was challenged by a number of people. One was Shandi Heffner. Now, Shandi Heffner, remember I told you, was the daughter in the eyes of the law. She was not just adopted, but she had standing as a daughter, and an immediate family member always has the standing to come into court and challenge a will. Doesn't mean you win, but she had the standing to do that. Irwin Bloom was a financial advisor. You know, over drinks, I'll tell you about Irwin Bloom. He eventually got indicted for embezzling. He was churning Ms. Duke's accounts, but he had been in a will at some point in time. Dr. Demopoulos had standing because he was the trustee of the prior will in time. And then the various banks who over time had been the institutional trustees also had standing, and they did come in. Dr. Demopoulos called us when Doris Duke died, and he said, I've just learned, because the lawyers for Bernard have called me and said that I was a trustee and executor of a will of Doris Duke. And we said, yes, we knew that. And he said, well, you never told me that. And we said, of course we didn't. That was her business. If she wanted to tell you, she could have told you. And he said, do I have standing to challenge the will? And we said, you do. And he said, you two know, never in her right mind did Doris Duke put that estate in the hands of Bernard Lafferty. Doris Duke believed that her father, J.B. Duke, was somewhere, I'll call it heaven, was in heaven watching her. And she knew her father would have, I don't know, had a fit if she had put the drunken, drug addict, illiterate Irish butler in charge of the $2 billion estate. So all these challengers came in. Don and I came in on behalf of Dr. Demopoulos. We told Dr. Demopoulos, we said, look, this is going to be a big fight. This is going to be a big, expensive fight. You've got a lot of people fighting over a lot of money, and we'll do it. In the United States, we can do cases on a contingency. That means that you don't pay us anything unless we win, and if we win and there's a recovery, then we share in the recovery. But we said, Harry, you've got to have first-class, white shoe, New York estate lawyers who do this with us, and they are not going to do it on that basis. They'll want to be paid by the hour, and you don't have deep enough pockets to be able to match Bernard Lafferty, who the presumptive executor and trustee, he had control of the fortune. He could pay lawyers as much money as he wanted to. So Harry, who was married to a doctor as well, they mortgaged their house to pay Simpson Thatcher, who were our estate lawyers. So there was a question about where this case would be set. There were a number of possible jurisdictions because Doris Duke owned property In Hawaii, that was Falcon's Lair. At New Jersey, Rhode Island, California, here's some pictures. Falcon's Lair is where we met her, the old Rudolph Valentino. Shangri-La in Honolulu is at the base of Diamond Head. Next time you're there, it's been turned into a museum. It's well worth going for a little tour. Rough Point is the cottage at Newport. Duke Farms she loved, and in the middle is the J.B. Duke House in New York, and it was a whole city block in New York at the time of her death. Any of those were potential places for the situs of the probate of the will, and I have New York really to make the point. New York is the only one of those jurisdictions where a probate matter goes to jury trial. You know, in the United States, we have a constitutional right to a jury, but not in all cases. And probate cases are one of the very few categories where a constitutional right to a jury is not afforded. It depends on the state law. The only one of those states that has a jury trial in probate is New York. And we have no idea to this day why Bernard Lafferty's lawyers chose New York to go to a jury trial, because we thought, we've died and gone to heaven. This is fabulous. We have the illiterate, drunken, drug addict Irish butler who murdered her versus the charitable estate. So this will be wonderful. We'll be in New York. We were in front of a judge named Eve Preminger. Otto Preminger, the film director, was her uncle. She's still alive. She's still a friend. She's actually been to Lady Margaret Hall for some of our lectures. Frances and Jillian have met her. I was hoping she'd be able to come tonight. Dawn and I had not ever had a case in the probate court in New York, and we had heard hearsay that court could be bought, just to put it bluntly. That there was underhanded bribes, and you could influence the judges on that court. I have no personal knowledge, but it did make us a little, we were wary of going into New York. It turned out that Eve Preminger is an honest woman. Maybe they all are. Maybe all the judges are. But she was an absolutely fantastic judge, and she was not afraid to call the shots as she saw it. And there were, as I said, a number of challengers. Bernard had 20 lawyers that were in court every time we appeared. I would be there, 20 lawyers for Bernard. And but she was going to keep an open mind and listen to what the evidence was going to show. The obstacles that we had to overcome: Lafferty had the money, so he could hire all the lawyers that he wanted to, and he had about 5 firms before we were done. There's a presumption that the last will in time is valid. We had to overcome that presumption. And there's very limited discovery in a probate matter in New York City. Medical records in particular are protected even after death. So you might think after you die, fine. No, they're protected even after death, and that became an important part of the story, as Dawn will tell you. Eccentric. Doris Duke was very eccentric. She was willful. She had her own ways. She thumbed her nose at society. This is Bernard Lafferty in the picture. At the end, when Bernard Lafferty actually became in Doris Duke's circle, as the years went on, he looked more and more like Doris Duke as the years went on too. And Dawn will tell you there's a twist to that in the estate part. And she had camels that grazed at her Newport, cottage. So she was eccentric. And when we went in front of Eve Preminger, she said, "I want everybody to understand something. I understand. I've got all these banks. I've got all these challengers to the will. The sharks are swimming. This always happens when there's a big estate, that the sharks come out and try to nibble off little pieces." And she said Doris Duke was entitled to leave her fortune to anyone she wanted to. She could leave it to a cat. She could leave it to her camels. She could leave it to her Irish butler, as long as it was done correctly, and as long as there was no undue influence, and as long as Bernard Lafferty hadn't committed any wrongs. So I'm going to now let Dawn tell you about us coming into the case at that point and the wrongs that we discovered and the way we dealt with them and the outcome of the case. You didn't have to clap.
Suzelle has told you that the executor under the prior will, Dr. Demopoulos, came to us, and when he found out he'd been executor, and asked about a challenge, and we agreed to do the challenge. But we told him at the outset that it was a steep incline with the obstacles that Suzelle just indicated to you. Now, when you do a will contest in the United States, in almost every state, and it's probably similar here, there are two fundamental bases, and as lawyers you argue both of them if they're applicable. One is lack of testamentary capacity, the inability to understand the nature and consequences of executing the will. So she didn't know what she was doing. This is the first basis when she signed the will. There was a signature. It was probably hers, but it may have been she thought she was executing a medical record, whatever, but did she know what she was doing? And the second standard, which is pretty universal in the United States, this is a New York case, but it's a similar standard everywhere, is was there undue influence? Meaning, among other things, was she unable to refuse or too weak to resist the influence of someone coercing her to sign this will? In this case, that was important because after she came out of the hospital, she had a minor stroke and she had the drugs that Suzelle told you about. And so when Bernard Lafferty put this will in front of her, was she really able to resist or refuse to sign it? Developing the evidence was difficult for the reasons that Suzelle mentioned, and yet there were some ways around or through some of those obstacles. So one of the rules in New York is that you have to have special circumstances to take the deposition, the sworn testimony of a non-party. In our civil litigation in the US, we have broad, far-ranging discovery. If anybody has any information that may be relevant or could lead to the discovery of admissible evidence, we can generally notice up, take their deposition under oath with a court reporter, and then use that to either cross-examine them at trial or to introduce directly if they're unavailable. We didn't have that in a will contest. However, in New York, where the subscribing witnesses, the people who witnessed the will, those official witnesses to the will are always available for deposition, even though they are not a party in the strict sense. And this was a mistake maybe that the Butler's team made, but there was probably a reason for it. The treating doctor, the chief treating doctor, was one of the subscribing witnesses. Now, that allowed us the right to take his deposition, which became very important in breaking the case, but it may have been done from their perspective to keep the circle as narrow as possible and not have someone else in who might actually have looked at what was her physical condition at the time. In any event, it opened an avenue for us to get testimony that we would not have been able to get otherwise. The second obstacle to developing the evidence was this medical record privilege that Suzelle had told you about. It's very strict in New York. It survives the death generally, that you can't get or publish the medical records. So we worked quite hard on this to convince the judge, Judge Preminger, through briefing and argument, that on balance in this particular case, where Doris Duke had no surviving close relatives, no spouse, no siblings, no children, that the reasons for the medical privilege were not as strong as they would have been in those other cases, and there was a strong need for them in connection with the will contest. And we eventually won the right, which was one of the key rulings in the case, to obtain the last medical records. Going forward on the two bases, lack of testamentary capacity, the first one, each side had medical doctors, prominent medical doctors, who would raise their hand and on the side of Bernard Lafferty say, yes, they'd reviewed everything and she had medical capacity at the time. On our side, they'd reviewed everything and she did not. As a lesson to the students, it's often the percipient witnesses, the real witnesses in a sense. Maybe the judge or the jury balances off the others and discounts them. But here was a percipient witness that made the critical difference. When we got those medical records, it turned out that on the very same day that Miss Duke had signed away to the new executor, Bernard Lafferty, a will worth about $2 billion, the liquid assets and the paintings and the homes and so forth. She had had that morning, because of the small stroke she'd had, a speech therapist visit with her and work with her. And the speech therapist recorded the results of her work with Miss Duke. I don't know whether anyone in the audience knows about speech therapy and the tests that they give, but there are so-called one-step, two-step, and conditional tests. And they go like this. So the speech therapist would say, for a one-step request, raise your right hand. Or if you have telekinetic properties, raise my right hand. But raise your right hand, one-step request. Two-step request, raise your right hand and then touch your left ear, 2 steps. A conditional request would be, raise your right hand if I'm wearing a white shirt. So on the day that she signed this will to Bernard Lafferty, the speech therapist recorded in those records that Miss Duke could comply with most one-step requests, some two-step requests, and no conditional requests. So when we had that evidence, we had something very strong on the testamentary capacity portion of it. As to undue influence, it was the key there was the testimony of the doctor who had to give his deposition because he had been a witness to the will, a subscribing witness. Now, that deposition was heavily contested. As Suzelle said, they had 20 lawyers. We put a video camera, which was relatively new practice in those days, on the witness. They felt, for reasons I'll never understand, that I was being too firm with him or some silliness like that. And they put a video camera on me, and then we put one on their lawyer. So we had dueling video cameras, and we had 20 lawyers at a long table, and that deposition went on for 7 days. And what you have to do as a lawyer, young lawyer taking this kind of a deposition, is you have to get a pearl here and a pearl there, and then you wait to string them together to make your case. So the excerpts that I'm going to show you were not taken all at once. They were not consecutive. So at some point in the testimony, during the 7 days, we had the medical records here, remember, so I could put records in front of him. You said it is understood, it's understood that the medication, which was morphine, may shorten the life. You understood that? I asked him. Oh, I think, he's thinking now, yes, I understood that. Did you ever explain that to Miss Duke? Specifically, again, he wants to think. Yes. I don't recall explaining it to Miss Duke. So I left that there. We went on to other subjects. Later in the deposition, when you started the morphine, there was no indication of pain here in the records, is there? I'm putting the records in front of him. No indication of pain. She was pain-free from the Demerol. Remember, she'd been having the cocktails of Demerol, so she's pain-free. Again, this is a big ellipsis between these. Much later, maybe a different day. When you say you increased the morphine level so she wouldn't linger, because he was going to dress it up, why did you do that? Well, so she wouldn't linger. So we call it what it is. You mean so she would die? I increased the morphine so she would not linger. He wants to go back to that she would not suffer, and ultimately that she would die, perhaps shortly or sooner than she would have otherwise died from her medical conditions, which I judged to be within 48 hours. A 48-hour period would be of a terminal nature. Now, in New York and California and the United States, and I'm sure it's the same here in England, it doesn't matter if you murder a 2-year-old infant or a 98-year-old person who might die within a day or 2 days or a week or a month. It's murder in either case. So when that testimony came out, when we adduced that from him in the deposition, Suzelle got up from the table, left the room, and called our ex-district attorney, Ira Reiner. Ira Reiner had been the district attorney for Los Angeles. He was married to a judge that we had been in front of and had become friendly with over the years. And we asked him, Suzelle called him and said, I think I just heard a doctor confess to murder in the deposition, on the record, on videotape. Will you serve as an expert witness for us? And he did. He put together what's called the murder book when you're doing it as a prosecutor, which is the basis for a trial for murder. So I asked him, Dr. Kivowitz, you increased the morphine drip. Yes. Why was that? He's forgotten what he told me 2 or 3 days ago. I wanted to end the agony of these last few hours of her life. She wasn't feeling anything at this time, was she? Well, no. Do you agree with me she was not suffering? I agree she's feeling no pain. So he's increasing the morphine, she's feeling no pain, but he's justifying it to end that terrible agony that she's in. Now, when you have a case that, this was the largest estate, charitable estate case at the time ever challenged in the US. When you have a case of that magnitude, it gets lots of press. And one of the wonderful things about the press is it brings people out of the woodwork, witnesses that you might not ever find otherwise. This is the testimony of nurse Tammy Payette. And Payette had been a nurse in the house during Miss Duke's last illness and during the time the will was signed. And the nurses become almost like furniture to the doctors and to the lawyers and to Bernard Lafferty. They sit over at the side and they keep notes, and after a while nobody notices they're there. We do sometimes in trials, we do mock trials where we have a focus group that we will argue both sides of the case, one of us taking each side, put them behind a glass window, and then watch them deliberate. They know it's a glass window. They know we're watching them. But within 15 or 20 minutes, they've forgotten all about that, and they go at it, and we can get a feeling for how a jury might react to a case. Exactly the same way they treated the nurses. So Nurse Payette, they had they cremated his body within 2 hours and disposed of all of the nurse's notes. She was Catholic and felt guilty that she had been an accessory to a murder. And so she had made and kept a Xerox copy of the nurse's notes, not the medical records that we got from the hospital, but of the nurse's notes. She came forward to us and she brought those notes and she testified that Miss Duke's life expectancy, she said at the outset, because she just had a facelift, was 5 years. And if she'd been kept on a rehabilitation regime, but instead Dr. Kivowitz put her on a massive sedation regime. She began to break through or recover consciousness. Despite the Demerol, she was a very strong character. Kivowitz had a long meeting, the doctor I deposed, with Doyle, the lawyer, Lafferty, the butler, and Dr. Glassman. He was the doctor who did the facelift. He was married to Victoria Principal at the time as a prominent plastic surgeon in Los Angeles. Yeah. Actress, Victoria Principal, yeah. So they all came into Miss Duke's bedroom, so they had a little conference there. And Dr. Kivowitz told the nurse it was time for Miss Duke to go, time to go. At this time, Miss Duke's vital signs were still stable. She was not in any distress or pain, confirmed exactly the testimony from him. Miss Duke's body was removed from the house less than 2 hours after her death, and I was told by Bernard the body was to be immediately cremated, which it was. So, lawyers, what do you do with this case? Well, we knew we'd get to a jury eventually, but we had lots of contestants. And remember, the main things that changed in the wills, the sequential wills, not that they were to go to a charity, it was always to go to a charity, but who was the executor and trustee. So we thought we might find a shorter way to get where we needed to be. In the discovery, we found that Bernard Lafferty, remember, was indigent. He had really been rehabilitated to some extent by Miss Duke. He would repeatedly go out to Hollywood and be found beaten up in an alley and this, that, and the other, but he had no money. So when he became the trustee and the presumptive executor, he went to U.S. Trust, which you remember was the co-trustee, but he could fire them, and he asked them for a loan of about $825,000. Bernard went into the first floor of U.S. Trust, and he filled out the loan application and slipped it across to the teller. And that went upstairs until it came up to a vice president, and it came back, and the teller had said, he has no assets, we can't loan him this money. And the vice president wrote a note on it, which we got through discovery. You don't understand, he can fire us, make him the loan. They made Bernard the loan, so we filed a motion to disqualify U.S. Trust. This is still the only time that an institutional trustee has been disqualified in the United States probate law. This is our argument from our paper on that, the brief. Loaned him $825,000, thus fatally compromising its duty of loyalty to the estate and the beneficiaries, becoming aware of Lafferty's misconduct, and by this time, Bernard Lafferty was wearing Miss Duke's clothing. His hair was grown long and blonde. He was sleeping in her bed. He did not have a driver's license, but he took her car out one day in Hollywood and crashed it into the walls of the Whiskey A Go-Go in Hollywood and was picked up there by the police. When they learned of his misconduct, it was forced to choose between exposing him or concealing his misconduct. This put the bank in a position of irreconcilable conflict of interest, its own interest and those of the beneficiaries. This is Judge Preminger's ruling, part of it. If there was ever a need for a corporate fiduciary to rein in the excesses of this unsophisticated and unknowledgeable individual co-fiduciary, it exists in this estate. U.S. Trust has failed to discharge this duty to the estate and to the charitable beneficiaries. They were disqualified, they were out. So we now had 1/2 of what we needed, we thought, even without a trial. So we then brought a second motion, parallel to the first one, to disqualify Mr. Lafferty as executor. This, too much detail here, but we'd asked for a special master to be appointed. Richard Q was a lawyer in New York, very prominent. He did the, what were the brothers? Yeah, he did another prominent estate case some years ago. But in any event, we wanted this because we were fighting so many lawyers. The Von Bulow case was Q's case. So he came in, and it was very helpful because he could then organize and supervise the discovery. And he wrote a report that he was essentially a person with no assets till the earliest or last months, but his total expenditures during this period appear to be well in excess of $1 million. He was buying diamond stud earrings, he was buying fur coats, he was giving Elizabeth Taylor flowers every day and other movie stars. He was on a party. So the ruling from Judge Preminger, Lafferty's personal financial situation, evidences a lack of appreciation of the basic financial matters and a cavalier attitude toward money in general. No one could read this sorry record and conclude that the Duke estate has been provided with the loyal and honorable service that the law demands. So Bernard Lafferty is out. This then gives us the opportunity to resolve the case without the trial by going to the other prior executors under the prior wills who brought challenges and agreeing that we would have a board, including our client, Dr. Demopoulos, including the head of Duke University, including a designee of the Attorney General of New York, administer the charitable trust along with an institutional trustee. That was established by settlement and resolution of this case in 1996. Judge Preminger found that our proposal overwhelmingly was consistent with the charitable intent expressed in all of her wills. So she didn't have to choose between the wills in order to get this resolution. The legacy of that case, the foundation, Doris Duke Charitable Foundation, now being properly administered without the Butler, making grants to the arts, the environment, medical research, and the well-being of children, is now worth over $1.6 billion because of the earnings on the growth, and it's already given away $1.1 billion. So it's been a very fruitful legacy, and our client was delighted that it went where Ms. Duke wanted it to go, did not insist on having a challenge to make himself the only executor, but went on to the board. There's the inevitable book. Her nephew, Doris Duke's nephew, wrote the book. He interviewed us during the case, asked for photos. The case was 25 years ago, how young we were. But he published the book finally in 2014 after pulling together all of his research. And it has 2 chapters on the case with a lot more of our testimony. So let me just finish with something that you won't read in the book and you won't see in the court records. When we got the U.S. Trust thrown out and we were hot on Lafferty's tail, there was tremendous publicity in New York. So he went to the lawyers and he had them write a will for him. And he publicized that will. And he went on television and he said, I'm like Miss Duke. He said, I have no spouse, I have no children, and I've written my own will. And I've given everything I've got, all the fees I've gotten, everything, when I die, all goes back to the Doris Duke Foundation, charitable foundation. Now, are any of you old enough to remember a movie with Walter Huston and Humphrey Bogart called The Treasure of the Sierra Madre? In the I think Walter Huston got an Academy Award for that. In The Treasure of Sierra Madre, prospectors go out from the United States into Mexico, the Sierra Madre Mountains, and they find gold. And they're having trouble with bandits along the way. The immortal line is when they're being attacked by the bandits and they say, show us your badges. We don't need no stinking badges. That's the movie. As they found the gold and they're going back, they've taken sacks, small sacks, put the gold dust into the sacks and put it in with hides on their donkeys. And they're taking it back to conceal it, to get it back. The bandits find them and kill most of them and take all of the donkeys and all of the hides. And when the bandits find the hides, they find this dust sewn into the hides. And they think, well, these terrible gringos, they're making these hides heavier so they can sell them for more money. And so they take the dust out and they beat out all the bags because they're honest bandits. They're going to sell the hides for what they're worth, right? And all of the dust goes back out into the desert. So at the end of the movie, the gold dust has done a complete revolution from the Sierra Madre back to where it was found. In the time after we got Bernard Lafferty thrown out, I do not say, and I go on record here, I do not say that anybody killed him, but I do say that people who had an interest and a hand in this, doctors and lawyers, did not need or want a voluble, drunken butler going around talking for the rest of his life about what really happened. So what they did do was make available to him all the drugs and alcohol that he wanted. Within 6 months, he was found dead in the Breakers Hotel down in Florida. In that 6 months, he had never thought to change that phony will. So in fact, other than what he spent, everything that Bernard Lafferty had taken out of the estate did, like the gold dust, go right back to where it came from, into the charitable estate. So I hope there is some redeeming social value in this particular program today. It's a fun case, and I hope you enjoyed hearing a little about it. The book is available, I think, on Amazon, but it's light reading. Mostly it's about her life. But we enjoyed doing it. We enjoyed talking to you. If you got something educational out of it, then I'm pleased with that. But I hope you had a pleasant evening, and I want to thank you for coming. We have drinks at 6:30. Suzelle, I want the record to show, went from 5:15 to 6. I went from 6 to 6:25, but I think we have 5 minutes, if we can, for questions.
Were there any questions?
Yes, sir.
You said that the 2 grounds in which you could challenge the will were undue influence and the capacity to understand what was being cited. I was wondering on what grounds you could challenge Lafferty and the bank as viable trustees?
Well, yes, that was different. We did not need those other grounds in order to get them thrown out. In the case of the bank, what we showed the court was that they had an irreconcilable conflict of interest, and she decided that was sufficient to get them thrown out. For Lafferty, when we put the evidence in front of her about his profligate spending, there's more than I've told you here. He took all the money out of her account by just signing, you know, at the back of a checkbook here, do you have those little things where you can make a withdrawal? Well, anyway, you used to in the old days. Now it's online. He just filled one out for, you know, $1 billion, almost $1 billion, and just turned it in. And they actually sent out vice presidents to meet, make sure it was valid and so forth. But him, it was because he was not managing the estate properly. He was profligate with the money, not looking after the interest of the estate.
So can anyone bring that? Did you?
No, you have to be able to, you have to be in the will contest in order to move to disqualify the executors. Yes?
What happened to the doctor?
That's a very good question and often asked. After the case was resolved, there was some initial effort by other medical doctors to have him brought up to the board and disqualified, et cetera. We talked to our expert, who was the ex-district attorney for Los Angeles, and he said, it's probably not going to go anywhere. You don't have anyone who has a real incentive to move it. If we were putting together the murder book to try him, you have to be sure you're going to get a conviction, not just that you have enough evidence. Long story short, he's still practicing medicine. He's still at Cedars-Sinai. If you go there, don't let him give you a cocktail.
But that's a doctor asking the question. Harry Dimopoulos was very outraged, personally and on every level, and he wanted to see the doctors indicted and charged criminally, and he pressed on that. But there was a very political time in Los Angeles for the district attorney's office. They had lost a couple of high-profile cases with acquittals, and Ira Reiner explained to us it's always a discretionary call for the district attorney to pursue a murder case, and the doctor will say it was a mercy killing. I know there's lots of evidence to the contrary, but they made a political decision, and we were never happy with it, but, you know.
There's a film that you can get on Netflix. And it's about an hour and a half. Is it done by BBC?
BBC Canada.
BBC Canada, called The Will. And in the film, Suzelle and I narrate the different scenes, and then they have actors portraying us. And the judge, Preminger, this is well after the case, narrated a scene. When Suzelle called her to ask her if she would be willing to do that, she said, I will, and if they ask me, I will say it's murder. And we said, well, we can give the testimony because that's in the court record, but better you saying it's murder than us saying it's murder. But actually, I like that film a lot better than Suzelle does. If you see it, you'll know why. The actor portraying me is young and buff. You know, looks about like me. They have a matronly woman for some reason portraying Suzelle. So she didn't enjoy it nearly as much as I did. Jerry?
I liked your Treasure of Sierra Madre metaphor, but being an opera fan, I want to call your attention to the fact that Wagner wrote 4 operas on the subject called The Ring of the Nibelung.
Oh.
Exactly.
Ah, okay, all right. Well, I'll use that. I'll use that next time. They say plagiarism is stealing from one person, research is stealing from many. So I'll adopt that. Jackie?
You said that New York unusually didn't allow for jury trial.
Did. New York was the only one of the where she had a residence was the potential. You could have filed anywhere where she had a residence. We thought that her primary residence was the Duke Farms, the old family estate in New Jersey, which is why we brought in the New Jersey lawyers to write the will. They probated where she had a residence in New York when none of the other 4 jurisdictions would have allowed a jury. And we thought that was a mistake. And often in law, you want to minimize your own, but capitalize on those of the other side. And they made several mistakes.
But in the event, of course, you didn't have a jury.
Right.
Actually, the case as it stood, you were better off with it.
We ended up resolving it with the judge without ever getting to the jury stage, which would have been quite involved because you would have had to decide among all of the wills. And when we could get the estate and our man as one of the executors, which he is today, we thought we'd done our job and went home.
It could have lasted another 10 years in the probate court. And you might be interested to know, you saw the list of contesters. One was Chandi Heffner, the daughter. People often say, well, what happened? What did she get? Because she was a party. Chandi Heffner got a $100 million settlement from the butler before he was removed, while he was still the presumptive executor and trustee, and she was on a contingency with her lawyers, so they got about $40 million. And so she took her money and went away. Erwin Bloom was the financial accountant that was
He went to jail.
He was churning the books. He was churning her stocks, and he went to jail. And then it was a whole bunch of banks. And so at the end, it was Dr. Demopoulos and the banks and the Attorney General of New York. And there's always a role the Attorney General plays in a charitable trust and estate issue. So they came together, and essentially we crafted the settlement. And the 9-person board includes the president of Duke University, Dr. Demopoulos, the Attorney General of New York, and some others. And since Tim's gone out right now, but I know Tim and Alan are thinking, well, how can Lady Margaret Hall get in on this? It is heavily weighted toward New York charities. So there were some nights when Dr. Demopoulos and Don and I engaged in some fanciful thinking about, well, if we really hit a home run and Dr. Demopoulos is the individual executor and he has control of the estate with an institutional investor, but as long as he did things that were reputable, he would have been able to pretty much call the shots. And yes, we did think of the charities we love best, but now he's only one of 9, and so we tell people who come to us, he's one of 9. We'll tell Harry, we love you, but they have really focused the money on New York charities.
The settlement that Chandi Heffner got from the butler before our case went to full conclusion has led Suzelle to give the following advice to people about
No, sorry. Yeah, go ahead.
about being adopted.
Oh yeah, if you have a choice, yes. If so, you meet a very wealthy woman or man, and you want to get their fortune. So don't marry them. Have them adopt you, because you can be
You'll
divorced.
always have standing.
Yeah, but you'll always have standing to challenge the will.
Yes.
I think I've got the chronology right. Correct me if I'm wrong. Demopoulos went from knowing nothing about being a trustee to discovering this, to mortgaging his house to fight for the right to be an executor.
Yes.
Could you talk a little bit about his motivations? Because clearly there's an economic side to this. He mortgaged his house. There was also a moral side, but that going from zero to mortgaging a house to getting into this fight in that way, that's quite a move.
Right. So let me start. When he was named the executor under the will that we brought in the attorneys to draft, it was not our role or their role to go to him and get his permission or give him information about that. We did not. If Miss Duke had wanted to tell him, she was welcome to tell him. Sometimes she did that to tease people. She didn't. So she never told him about that. He only found out because when the Lafferty will was probated, they have an obligation to disclose all the prior wills. And at that point, he was called and told he was executor, there was a prior will, which is when he came to us. And so his motivation, Suzelle can give her opinion, I think was twofold. It is absolutely true what Suzelle said, that Miss Duke called Bernard with a bell. We would travel on her 737, 3 pilots, Miss Duke and us, Bernard in the back, bring up sandwiches, and ring a bell to get him. He never sat in on the business meeting. So he felt strongly that Bernard was going to squander this money, not give it to the right people, and that Miss Duke never wanted Bernard in that position. There would have been a very substantial upside for him if he had become the executor at the rate of 6% in New York. I think it's telling about his motives that at the end of the day, he was satisfied with a seat on the board. I think the compensation for the board members is about $250,000 a year, but it's nothing like what he would have gotten on the others. Suzelle, do you have a different view?
So just to add to that, Harry Demopoulos had known Doris Duke for over 25 years, when all this started happening. He was a close friend of hers, and he really cared about her. And he vehemently suspected foul play. We didn't know that we could prove it. You know, we came in and we were like, okay, you know, same reaction that Judge Preminger had. Okay, Bernard's, it's a weird choice, but she's entitled. But Dr. Dimopoulos was convinced that something really bad had happened. Plus, Bernard had shut him out, which in Harry's case was much more personal because he had a relationship with her and his feelings were hurt. And he really wanted to know what went on. So he was determined to do, and he also thought that it's just immoral that this estate is going to be squandered by, you know, the Irish butler. But when we got the medical records, Dr. Dimopoulos came out to Los Angeles and he stayed at our house in Malibu, and we took all the records, and there were boxes and boxes of them, and we spread them out all on the dining room table. And for 5 days, Dr. Dimopoulos, Dawn, and I went through the medical records and we annotated. And the results of that you see in this cross-examination, which, you know, Dawn showed you a few snippets of it. But this was literally months of preparation. But Dr. Dimopoulos wanted to see them himself, James. So he came out and he helped us understand. We also had an expert who was a medical doctor, a pharmacologist slash, I don't know what the medical word for pain doctor is, but that was his specialty. And so we retained him to look at all the drugs that they were giving her and to tell us whether those were, you know, proper. They were not. But he was very conservative. He's actually British, but lives in Los Angeles, very conservative. And he said, look, you know, doctors can be pretty liberal with what they prescribe for pain. This was 25 years ago. And, you know, it doesn't rise to the level of anything untoward unless it's really bad. So we said, well, you just look at the records. And he said, yes. So he looks at the records and he calls us about 24 hours later and he said, I've just started going through the records. And he said, and I want to tell you, just on my preliminary view, this is terrible, this was unethical, this was immoral. And in the bills that I found, the doctors were charging her $100,000 a month to come make house calls. How can I get in on a deal like this? It was a joke, but that was just, you know, we could go on all night. The things we found about how Doris Duke was taken advantage of were just epic.
But if I could just make one point, following up on something you said there for the young lawyers. Suzelle's absolutely right that what you see in the cross-examination, especially the few snippets, is the tip of a very big iceberg. So it first took going through those medical records and understanding them and putting them together in such a way so that when they were put in front of him, you could drive him to the questions that the answers that you needed. And that's a very big effort. You don't simply go in and ask those ultimate questions. It's 90% preparation, and then the payoff is when you get the right questions. And just one last thing, and we really have to go to drinks. My blood alcohol is getting dangerously low. This wasn't the only case like this we handled. LMH, several years ago, had a similar case with a donor from the United States, and who was subject to undue influence and didn't have the testamentary capacity when she changed her will to cut out Lady Margaret Hall. We handled that case, and the money is back where it belongs at Lady Margaret Hall. Yes, Francis?
I was about to bring up that case, so I'm very glad you did. So in this case, there was no sex, no murder.
Yeah,
But the principle was the same.
It was.
It was that the intention of someone in their will was being diverted and falsified by a new will being created in extremely suspicious circumstances the very day before an alumna of this college died.
Right.
And I just wanted to say that it was terrific to see yourself and Suzelle paying as much attention to getting that sorted out with a small amount of money for this college as you did, as you've shown so rivetingly in this account, with sums of money way over $1 billion in the Doris Duke case.
Thank you very much, Francis.